Thank you, counsel. The next case we have is Kimberly Ann Reese versus the estate of Tina Marie Hernandez et al.
Oh, no. Sorry.
And Mr. Anthony is 5 minutes. Good?
Yes, Your Honor.
Okay.
That's good.
It is Mr. Anthony, right?
Yes, I'm Robert Anthony. Yes, Your Honor.
Okay.
May it please the court.
Yes.
Thank you. I represent the estate of Tina Hernandez, and Kimberly Reese is the personal representative. Tina Hernandez died in May of 2021, about 1 month after her divorce. Her divorce was in April 2021, so 1 month later she died. She was 55 years old when she died. She was married to Russ Hernandez, all right, so that's her ex-spouse for purposes of this appeal. Russ Hernandez had 2 children, Crystal and Danielle, and Tina Hernandez had 1 child, Courtney. The 2017 will that was prepared, it was prepared 4 years after they got married in 2013. Russ and Tina got married. The trial court determined that the 2 who at that time were former stepchildren were entitled to 2/3 of the estate because the secondary beneficiaries were listed as the 3 children. The trial order by Judge Soto was on a petition to determine beneficiaries. And what Judge Soto ruled was that because Crystal and Danielle were individually named in the will, they're the beneficiaries along with Courtney. Even though they were former stepchildren.
Mr. Anthony,
Yes.
so the children, and you're saying children and stepchildren were named, but in, I think it's the 4th paragraph of the will, it doesn't describe the stepchildren as stepchildren, correct?
Correct. It describes them as children.
And then even the definition later on in the will describes children to include stepchildren.
Correct.
Correct?
Exactly.
Okay.
It does.
Do you have any case law that you can cite to me that upon the divorce, the designation of stepchildren for purposes of inheritance is canceled out or rendered void based upon action of the dissolution or the divorce for purposes of the will?
The most applicable case that I have is the Isles case, the 1947 Supreme Court of Florida case, which specifically dealt with a wife, not a stepchild, but it dealt with the 1st degree of beneficiary. This is the 2nd degree of beneficiary. But that case, the Isles case, is still good law today. And in that case, it specifically holds that because the decedent in that case was divorced and his will provided that his wife gets everything, and if his wife does not survive him, it goes to the testator's brother in that case, not stepchildren. But the critical point of that case is that they say that the conclusion is inescapable, that Thomas Isles clearly intended to adequately provide for all his dependents who at the time had a legal or moral claim to his bounty. If neither class existed, no wife, no devise. And they said she did not survive him as a wife, and they said the critical issue in the case was whether the devise to the wife was conditioned on her being the wife upon death. conditioned upon. The will did not say that in the Isles case. The will just said it goes to my wife. If my wife predeceases me, it goes to my brother.
The applicable law that we have here conditions the analysis based upon whether or not it affects the surviving spouse or the, I guess your position is the non-surviving spouse. So those facts in the Eyes case are different than the facts that we have here, you would agree, because we have adult surviving children as specifically identified in the will. You would agree?
I agree that you just jumped to issue number 2. Issue number 1 is strict interpretation of the will and whether the Isles interpretation of the will, regardless of Section 732.507. Issue number 1 is strict interpretation of the word children. The word children, based upon the Isles analysis, the word children is a condition, and that condition was not in existence on the date of death. So you're talking about the word affects. The word affects relates to issue number 2, not issue number 1. Issue number 1, as far as the strict definition of the word children, the Isles case is as close to on point as you're going to have, except that it did not survive as a wife as opposed to did not survive as a stepchild. If you inserted the stepchildren's names into the will that's in the Isles case and had the brother as the secondary beneficiary, the Supreme Court decision in 1947 would compel this court to rule as a matter of law that the stepchildren did not survive as stepchildren. Therefore, they do not recover. And that's issue number 1. Now, issue number 2, about the word affects, that's based upon the statute that's currently 732.507. That statute was created in 2001, but its predecessor, which was 731.101, that was created in 1951, 4 years after the Isles decision, right? So the statute has had several variations since 1951. In fact, they've had some case law that has come out, and they had to make some changes to the wording of the statute because of some inconsistencies. But that statute has really only been talked about in the Carroll versus Israel case, Israelson's case. It's been slightly mentioned in other cases, but Carroll versus Israelson specifically talks about that statute and the word affects. All right, and so that's issue number 2, is if you don't rule as a matter of law that the word children is a condition and that's a class, those children are a class of beneficiaries, and the class did not exist upon death. Then you go to issue number 2. Issue number 3 in this case is the extrinsic evidence piece, all right, and that's really tied into issue number 2.
So as far as going back to issue number 1, your position, I believe, and I don't want to put words into your mouth, are that the identification of the stepchildren specifically as children and not stepchildren, identification by them as name, is irrelevant and has no meaning. Is that correct? No,
it's relevant as long as she was still married to Russ Hernandez. Even
though they're not identified as stepchildren.
Yeah, the only reasonable implication is that it was a family unit, and as a stepmom, she considered her stepchildren as her children. That's the reasonable interpretation of that's why it says what it says. So I'm not sure exactly your question, but they are identified by name in paragraph 4, which relates to tangible personal property. They're not even identified in paragraph 5, which is the residuary clause, and they're not identified in paragraph 9, which is the definition of children. But they are identified, and that is the strongest argument that the appellees have in this case, is that they're specifically identified, and Judge Soto said they're specifically identified. Therefore, I see no case law or precedent that would allow me to say that they're not beneficiaries. But that's not reading the Isles case as far as issue number 1. And then as far as issue number 2, we contend that that's not reading the Carroll versus Israel case, because Judge Soto distinguished the Carroll versus Israelson case. Of course it's distinguishable. Our facts are not even very close, but the principles that are set forth in Carroll versus Israelson are significant. Those principles include that the word affects is a broad word. It's not a narrow word, but the trial court before Judge Soto interpreted it narrowly.
Isn't the effect that took place in Carroll was that the residual or the value from the estate went directly, automatically to the trust? There was no contingency, which I think is here in the facts of this case.
Carroll is very distinguishable, no doubt. There was a trust. The court referred to some legal gymnastics. The appellate court referred to some legal gymnastics. It's not very clear from the decision, but it appears that what happened is that the ex-spouse did some maneuvering so that perhaps she could make an argument that she was not going to be a beneficiary, but the niece and the nephew were going to be the true beneficiaries. But the appellate court said, no, we're not going to go along with that. Because even if there doesn't have to be a direct pecuniary benefit, but the trustee in that case had control over the trust, and therefore the trustee could manipulate the distribution to the niece and the nephew and perhaps take distributions herself.
But was the trustee the ex-spouse?
Yes, Wendy. Her name was Wendy, I think, in that case. She was the ex-spouse, and the devise went to the trust, and she was the trustee of the trust. All right. There was a case recently, Grayheck. It's not cited because it just cited Carroll versus Israelson, and it was very similar set of facts. I think it was the 4th DCA, but there was no opinion. It just said affirmed Carroll versus Israelson. So yes, the facts are different. But the word affects, and according to the court, the word affects is a broad word, to have an effect on. All right? A provision, the quote from Carroll is, a provision does not need to have a direct pecuniary benefit to affect a former spouse. And any provision that affects the former spouse, according to the statute, is void. It's a nullity. So we argue that on issue number 2, if you're going to rule as a matter of law, the word affects, and you have 2 stepchildren who are your natural children, it has an effect on you because the definition of effect is so broad.
Is there any relevance to the fact that these children are, in the eyes of the law, adults when they're receiving their inheritance?
I see no relevance to that. Mr. Pepler argues that they're legal strangers. That is a stretch to say that just because you're an adult, you're a legal stranger. They're beneficiaries in his will, all right? They're his children. If he dies intestate, they're his beneficiaries. So I don't think it's irrelevant, Your Honor. I think it's absolutely relevant, whether you're a minor or an adult.
How do you measure or quantify the effect to the surviving spouse and the facts, based upon the facts of this case? It seems to me like you were hyper-focused on some sort of intangible, unmeasurable, emotional effect on the former spouse.
I certainly was focused on the emotional impact if you're going to rule as a matter of law, because the case law that I cited from other jurisdictions have held that if the will is primarily motivated by the marriage, and there's nothing within the will to indicate a special relationship between the stepchildren and the former stepmom, then the presumption should be that there's an impact and that it should be a void transaction. That's the California.
Doesn't that leave us open to abuse or expanding that? You could always find, in death alone, in death when you have relationships that are bonds between decedents, you're always going to have an emotional impact. So you're always going to have an effect. I'm trying to figure out where the line is if we take your argument to its logical conclusion, because the flip side could be that the children have no relationship with their father, like none, or maybe even a repulsion of any relationship with their father. So where do we stand? How can we reasonably draw those lines to determine the effect in this case, but more importantly, not open it up for abuse or unnecessary expansion in future cases?
That's a great question. And on issue number 2, that's an almost impossible question to answer. But the trial court said as a matter of law, I can say there's no effect. Wouldn't let me even take depositions. Granted the motion to have the hearing only on the 4 corners of the will with no extrinsic evidence. And we submitted the affidavit of Kim Reese that outlines all kinds of extrinsic evidence that this was going to be a financial disaster to Russ Hernandez, because 2/3 of the money coming into the estate was Russ Hernandez's money that he owed Tina from the divorce settlement. So his own children are going to get 2/3 of not only that money, but the other money in the estate. So to answer your question, effects, if you're not going to rule as a matter of law that it's a void, that these provisions are void, you have to at least let me go take the depositions, because it would be a question of fact. It would not be a ruling as a matter of law that it has no effect. The burdens should not be on me before I'm allowed discovery. I know I only have 3.5 minutes left, so I'd like to reserve some time for a rebuttal.
You may.
Thank you.
Good morning. May it please the court, my name is Thomas Pepler, and I represent Crystal Marie Hernandez and Danielle Marie Atkins, the appellees in this matter. My clients are 2 of 3 named residual beneficiaries in the will left by Tina Hernandez. Ms. Hernandez's intent, as expressed in her will, is clear. She left everything to her husband, and if he predeceased her, to the 3 named residual beneficiaries, one of whom is her biological daughter in lineal descent, and 2 who are the daughters of the former husband. As a matter of law, Mr. Hernandez predeceased Ms. Hernandez on the date of their divorce. Accordingly, the 3 named beneficiaries inherited the estate in 3 equal shares. We're here today because one beneficiary is a lineal descendant of Ms. Hernandez, and in the absence of a will, she would have inherited all of the estate. But there is a will, there are 3 clearly named beneficiaries, and the intestate statute does not apply. We submit that the holding in LaMontagne versus Hunter, 341 South 2nd, 1040, which is cited in my brief, is dispositive in this matter. There, the decedent left the entire estate to his spouse, and in the event the spouse predeceased, to his 2 stepchildren. There was a divorce, and the will was not changed. The brother of the decedent, presumably the intestate beneficiary, argued that the will was invalid, apparently because the stepchildren were the only residual beneficiaries under the will, and the defendant was divorced from their mother. The trial court agreed and invalidated the will. In that case, the appellate court reversed and held that the divorce took the wife out of the picture as if she was dead, and the 2 stepsons took were the named residuary beneficiaries as provided in the will, and they took the estate. This is exactly the state of facts in this matter. The holding on LaMontagne is directly on point, and there are no contrary holdings that I'm aware of under Florida law. In addition, the ruling in Owens versus the estate of Davis is typical and instructive. The case essentially holds that where the terms of a will are not ambiguous, it is error to consider extrinsic evidence to rewrite the will.
Counsel, may I ask a question?
Yes, sir.
And I'm not focused on extrinsic evidence. Do you have a copy of the will in front of you?
Yes, sir.
So the will is located beginning on page 14 of the record, and of course, preparing for argument, I've looked at the will numerous times. During appellant counsel's argument, I went back and I pulled up the will again, and on the bottom of page 15, the bottom paragraph identified as fourth. When the will provides that should Russ Hernandez does not survive the testator, then to those of my children. Do you see that? Fifth line from the bottom of that.
If it does not survive me, to those of my children.
Right.
Courtney,
So what am
yes.
what am I to make of this? As I was considering his argument, as I was considering his reading of the Isles case from the Florida Supreme Court in 1947, it says if Hernandez predeceases her, which of course by the divorce he legally has, you agree with that?
Yes.
Then to those of my children, then a parenthetical opens. And the three children as legally defined by the will to include the stepchildren are identified. Courtney Ring, Danielle Marie Atkins, Crystal Hernandez, and any other children which I may hereafter may have. And then the parenthetical closes. Is there any significance to the fact that that is a parenthetical that is meant to define the children then living? Well, irrespective, adult children, minor children, and the like. I mean, I'm curious your point on that, because of course, reading this over and over again, it hit me during the course of that argument. Is there any import to the fact that the parenthetical naming the three individuals further identifies those who constitute children at the of the execution of the will?
They do, in fact, identify the children at the time of the execution of the will as Courtney, Danielle, and Crystal. And then at paragraph 9, to make sure there's no misunderstanding, the testatrix included the provision, the terms child, children, and issue of the testatrix shall include any stepchild of the testatrix.
I wholly agree with that. I don't have any question that they, prior to the dissolution of marriage, would qualify as children. When this will was written, she was married.
Yes.
What I am trying to contemplate thoroughly in light of counsel's argument is if the dissolution of marriage occurs,
Yes.
and the husband is considered to predecease,
Yes.
do those identified in the parentheticals still qualify as children
Absolutely.
under that language?
Absolutely.
In other words, if she would have said, if Russell Hernandez predeceases me, then I leave the remainder to Courtney Marie Ring, Danielle Marie Atkins, Crystal Marie Hernandez, without the designator of children, but just names them. I think that's certainly an obvious outcome potentially.
Sure.
This potentially is written differently, and I wanted to at least to give you a reason. Tell me why, after the dissolution, do the two stepchildren still remain children, and it's the children to whom she left the items of the personal property in the fourth paragraph?
I think that the will is completely unambiguous. The will specifies and identifies the term children as to include her stepchildren. The will specifically states that if I'm using the term children, I'm including my stepchildren. Now, the case law is very clear that the interpretation of the will is the four corners of the will at the time of the execution, not at the time of death. And indeed, there are cases that say that it's not the court's job to do what she thought she was doing, but what the four corners of the will state at the time she wrote it. The intent at the time she wrote it was she wanted three specifically named individuals to take as residual beneficiaries. Indeed, the statute dealing with the automatic presumption of death on divorce only applies to the father. to the divorced spouse. There is no reference at all to it applying to stepchildren. If there's residual beneficiaries, there are, and there are at least 3 cases that I've cited in my brief where the stepchildren took automatically as stepchildren. Indeed, that's the whole point of the case in La Montagne.
At the time she died, were they her stepchildren, the 2?
There's a foreign case which doesn't apply in this case that talked about how they defined status at that time. They weren't stepchildren, they were residual beneficiaries. The issue here is that they were named specifically in the will. There's no way for the court to say that they weren't named in the will. And sorting through the cases in preparation for today, and I didn't find any cases that dealt with this, but there is an extremely old case, the state XREL Kumstead versus Hewitt, 138 Southern 778, 1932 case, where the court at that time distinguished and said when a testatrix leaves a will and devises property to her husband by name and identifies him as her husband, he does not take as the husband but as the named beneficiary. I can't find any other cases about that, but it's a 1932 Supreme Court case.
And can I backtrack just to clarify that I understand your argument? When you said that we're looking at the time of execution, not at the time of death. So were you speaking of essentially the class identification of children at the time the will was executed versus the time of death?
Yes. Well, it doesn't matter. The term children is descriptive. The controlling term is the fact that she named 3 specific adult individuals at the time of the will was drafted, and she referred to them as clarification, if you will, as, quote, her children. And then she clarified at the end of the will that even though I'm calling my stepchildren children, I include my stepchildren who are named as residual beneficiaries.
Understood, and I understand that's your argument. I just wanted to be clear. So essentially, for purposes of their father or the former spouse, we're looking at the time of her death, right? Because now at this point they're divorced, so we're presuming his death. But for purposes of the children, either identified individually or as a class, we would be looking at the time of execution.
Yes, and that is exactly what the case law mandates. And indeed, there are cases that when he talked about extrinsic evidence, there's a case that was cited in my additional authorities, Robinson versus Robinson, 676 South 2nd 511. In that case, the court said, we find no ambiguity in the testamentary provisions of a trust in that case. Therefore, we are compelled to reverse, notwithstanding that there is substantial evidence, inadmissible, absent an ambiguity, supporting the trial court's findings regarding intent. So the issue is, and that's what the lower court found, they found that they left them to 3 specifically named individuals. If there was some confusion about whether she wanted the stepchildren to be included or not, there was an express statement saying that she did want it. The cases very clearly state that you look at the 4 corners of the will. What was the intent at the time she wrote it? Not what she should have did or what she thought she did, but what was the intent expressed in the will? The intent expressed in the will is that it goes to those 3 children. No confusion over whether they're stepchildren or children. They go to those 3 people. That's basically the argument. They say we should file the issue about effects if the will is found to be unambiguous and the terms are very clear. 3 children and the amount of money given is an ascertainable amount. That's referred to in my opponent's brief. It's an unambiguous will. You'd have to find some strange ambiguity in the terms to go beyond that to say there's some extrinsic evidence. The case law says that the fact that they're stepchildren at the time of death is irrelevant. That's the La Montagne case and the other 2 cases cited in my brief. The foreign issue, those jurisdictions, all of that case law relies on portions of the probate code that the legislature in Florida declined to adopt. And if they decline to adopt it, it's presumed that they intended not to adopt it. So that all of those cases are inopposite. I would submit that there is no ambiguity, and quite frankly, nobody raised the issue of ambiguity. They just raised the issue that it doesn't seem fair that she left the money to stepchildren. And that's exactly what happened in LaMontagne. Clearly, the judge thought that that's really unfair. They're not children anymore. They're no longer stepchildren because there was a divorce. We can't leave it to those two. We're going to invalidate the will because that's all that was left. And the appellate court said no. They identified two stepchildren to be the residual beneficiaries. At the time of death, they were the named residual beneficiaries. They took the estate half and half, and the intestate beneficiary who would have taken got nothing. That's our argument in total. Without a finding that there's some clear ambiguity on the face of the will, and I submit you cannot do that in good faith, since it does say, she does clarify that I intend all three to be residual beneficiaries. There's no extrinsic ambiguity. There's no additional witnesses. There's no effect. The case the only Florida case on point is the case that says, well, yes, it was left to the trust, but she was the trustee of a revocable trust, which gave her the authority to do anything she wanted. And under the facts of that case, that was clear. But you have to have something like that. We don't have that here. So I would submit that the lower court's rulings were correct. There's no issue of anything. The threshold issue of interpreting this will has not been met, and the lower court should be affirmed. Are there any other questions?
No, sir.
Thank you.
May it please the court?
Yes.
Thank you. I only have 3.5 minutes, so I will try to be concise. All right. LaMontagne, that LaMontagne case, it does work against me. But there's a principle of appellate law. When a case is short on facts or devoid of facts, it's not precedent. It's not persuasive precedent. LaMontagne cited a case called Fredericks, which the Shriners Hospital was the contingent beneficiary, not a relative, not a stepchild. Shriners Hospital was. And so the court in Fredericks ruled that Shriners Hospital should receive the contingent beneficiary status. Amazingly, LaMontagne cited Isles. They cited Isles without discussion. All right, without any discussion about what does the word children, stepchildren, or those words in the case, what do they mean? The LaMontagne case, in one reporter, it's not even a page long. So it doesn't have sufficient facts to be persuasive authority for you. The Isles case has significant facts and significant holdings, and specifically says and holds, it's binding precedent, Supreme Court of Florida, that the devise to the wife in that case was conditioned upon her still being the wife at the time of death. So at the time of death, the parenthetical, my children, parenthetical, 3 children who at the time were part of the family unit, 2 of them aren't my children anymore. Right? And at the time of death is when you need to interpret, what does my children mean? What was the intent when she said my children? Well, the intent, and based upon the cases in California and Maryland that go into detail and talk about it, the intent is that provision's primarily motivated by the marriage. And if there's nothing else in the will to indicate a significant, substantial relationship between the stepmom and the stepkids, the presumption should be, yes, they have to survive as her stepchildren.
Are you asking us to go outside the text of the will as written with that argument?
To go outside no, you can interpret the word children. I mean, those cases talk about how do you interpret the word children when they're no longer children. They're ex-stepchildren. That's what the case is. California, it didn't have...
The focus is not on intention. The focus is on the language expressing intention. You would agree with that?
Yes.
Okay.
Yes.
Okay.
Right. And I know, Judge Sowd, I know that you've written articles, or you're cited in the Florida Bar Journal article that just came out, the James case, where you have a specially concurring opinion, where you go through all of the different principles of statutory interpretation, will interpretation, contract interpretation. All of those principles, the final result is, what's the fair and logical and common sense interpretation here? They must survive as her stepchildren. They did not survive, or when she died, they were not her stepchildren. And therefore, the trial court should be reversed.
Thank you.
Thank you.
It's well argued. Thank you, counsel, on both sides. And we stand in recess. Thank you.
All right. Your Honor.